Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin. Wassalatu wassalamu ala Rasulillah wa ala alihi wa sahbihi ajma'in, amma ba'd. Honorable Vice Rector of UEN Syarif Hidayatullah, Dr. Anas Basri, MA, PhD, Honorable Vice Rector of UEN Maulana Malik Ibrahim Malang, Professor Dr. Ahmad Tohir Talabi Kali, participant from the University of Malaya, deans, professors, reviewers, and plenary speakers, Associate Professor, Professor Dr. Nusayri bin Mat Hussein, Dr. Balawin Jones, Professor Dr. Hamam Izzada, Professor Dr. Zora Jacob, Professor Dr. Anca Misbah, and Professor Dr. Hajjah Mufidah. Distinguished academicians, judges, legal practitioners, policymakers, civil society activists, postgraduate students, and conference participants from Indonesia, Malaysia, Australia, Germany, Hungary, and other countries. I'm deeply grateful to be here this morning in Malang for the 10th International Conference on Law and Justice, which is taking place under the theme that I consider exceptionally timely: Reimagining Law and Justice, Bridging Inequality and Protecting the Vulnerable and Changing World. Let us begin with a moment of quiet contemplation. The longer I have lived and worked in the worlds of law and the government, the more I have come to understand that the legal problems cannot be solved merely by reading articles and clauses. Article matters. Legal certainty is fundamental. The procedure must be followed. I come from the field of constitutional law and understand that a law governing a state cannot rest on emotion alone. The absence of clear legal provisions makes arbitrariness possible. Without an orderly procedures, justice can easily turn into decisions shaped by whoever has greater power, who stands closer to authority, or whoever is more skilled at manipulating circumstances. However, my experience in law and the government has taught me that law must never be a collection of norms and paper. Legal provisions regulate action, but human beings are the subject of those provisions. Procedures govern the process, but those who move through it are individuals from fears, hope, and limitations, and suffering. The state's power must be wielded in accordance with the moral principles encompassing the goals of its application, the beneficiaries of protection, and underlying values influencing decisions affecting the life of many. I have examined the talk of Mohammad Natsir, the Indonesian Islamic leader who once served as the Prime Minister of the Republic of Indonesia, on the relationships between religion and the state. The concepts upon which reflected may be called the theistic democracy. It is not a religious state in the narrow sense, nor it is a state imposes piety through the power. What I understand from Natsir is something more profound. The state must be neglect the task of cultivating the ethical character of its citizens. Democracy is sufficient if it is reduced merely. Democracy is insufficient if it is reduced merely to the process of electing leaders. A constitution cannot function properly in the people who operate. It loses the honesty, sense of responsibility, and respect for one another. Muhammad Natsir once said that a constitution cannot change men. I believe this is a deeply important statement from our forum today because this conference invites us to reimagine law and justice, especially for those who live in vulnerable positions. I believe that we must speak about ethic of civilization. The law is standardly needed by the state. The state needs institutions. Institutions require procedures. All of these elements are essential and must never be taken lightly. Without institution, law becomes a noble sentiment without a binding force. Without the procedures, the power may move without clear limits. However, institutions and procedures alone are insufficient. They must be animated by the ethical awareness that power is not a private property, but a trust bound by certain values. Individuals who encounter the state must not be treated merely as numbers in an administrative system, application files, or administrative objects. They remain human beings with dignity that doesn't disappear simply because they are poor, weak, less educated, victimized, or caught within the legal process. In my view, the clearest measures of the success of the law is found in how it deals with just most easily ignored. In the law works well only for those with power, education, and access, it cannot yet be called justice. The law acquires its deepest meaning only when it is most vulnerable. Vulnerable persons can still feel the presence of the state treating them as a human being with dignity. The conference theme is grounded in the complexity of our age. Climate change has caused some people to lose their homes, land, and their livelihoods. Digital disruption has opened up new opportunities, but has also created new forms of exclusions. Forced migration and the human movement caused by conflict, poverty, disaster, and economic pressures challenge the existing boundaries of the national law. Social inequality means that access to justice is never fully equal between those with and without resources. Change burdens are not evenly distributed. Strong people usually find ways to adapt. They they have networks, knowledge, resources, and people they can call for help. For women who are victims of violence, children, people with disabilities, indigenous communities, refugees, migrant workers, the poor, or groups with limited social influence, the law often presents far greater challenges. They do not always encounter the law as a fully equal citizens. Many individuals must first demonstrate that their voice are worthy of being heard. Scholars often distinguish between law in the text and law in practice. In the literature, the law appears orderly. All individuals are declared equal in its articles. Human rights are guaranteed in the Constitution. Yet, when laws are applied in every life, the problems become more complex. A person who does not understand legal terminology may lose before the case is heard. A person without money for transportation may fail to access formally available services. A person without documents might be treated as their very existence is not recognized. Children who are victims of violence may be asked to repeatedly recount their painful experiences to comply with the procedures. Persons with disabilities may come to a legal service office only to find that its space, language, and institutional habits are not adequate to meet their needs. Therefore, the question is not simply whether the law sexist. The deeper question is whether the law can truly be accessed, understood, and felt as a protection versus who needed it most. This is where the gap between legal text and lived experience become a real justice question. The 1945 Constitution preambles outlined the purposes of our state, which is safeguard the entire Indonesian homeland and its people, to promote the general welfare, to educate the nation, and to contribute to a world order based on freedom, lasting peace, and social justice. This statement is not constitutional declaration. It is a moral mandate. The state was not established for its own sake, but for the protected human rights, protected the human beings. For that reason, when we speak about national criminal law reform, we must not merely see it is as a technical exercise in replacing the legal code. The National Criminal Code, enacted through the Law Number 1 of 2023, and the new Criminal Procedures Code, enacted through the Law Number 20 of 2025, which come into effect on January 2nd, 2026, should be seen as a component of the broader initiative to reform our criminal law. From the legal system, it is more focused on punishment toward the legal system that also seek restorations. But a law that simply asks which article has been violated to one that asks what harm must be repaired, what kind of victim must be restored, and what kind of society we want to rebuild. I'm not suggesting that punishment has no significance. The state must remain strong despite the prevalence of crime. Acts of misconduct must be dealt with firmly. Some offenders must be held accountable. However, modern criminal law should not be limited to retribution. If law functions only an instrument of retaliation, it might safely a momentary emotional need, but it will not necessarily help the society. Restorative justice doesn't imply immunity from the law. Restorative justice doesn't mean that every case must be resolved through reconciliation. Restorative justice emphasizes that justice should be measured not only by the length of the sentence, but also by the recovery of victims, accountability of offenders, and repair of the damaged social relationships. For victims, justice is often not only about the verdict of sentence. Justice is the recognition of suffering. Justice is essentially a sense of safety. Justice is the chance to live again without being burdened by traumas. The revised Criminal Procedure Code is also of great significance because procedural law is the face to the rule of law in everyday life. Many people fear that the legal process more than outcome. Legal proceedings can be lengthy, costly, complicated, and exhausting. Effective procedural law must ensure due process, respect the rights of suspects and defendants, protect the rights of victims and witnesses, and take full account of vulnerable groups' needs. Individuals with disabilities require more than just equality before the law, as legal institutions must also provide accessibility and adequate police offenders, correctional officers, policymakers, and academics must work with one shared awareness. A human being is not a case number. A person cannot be treated like a digital file. A human being is not a statistic. Let me offer a simple analogy. When we visit a doctor, we certainly want the doctor to examine our laboratory result. However, we also need the doctor to look at our conditions, listen to our complaints, and understand our medical history. A doctor who focuses only on numbers in a laboratory report and ignores the patient's symptoms might misunderstand the illness. This is also governed by the law. The legal provisions are the laboratory result. Those who come to the law are the individual in need of its assistance. If the law reads only the articles and ignores the human dimension, justice might lose its essence. This challenge has an even more complex dimension for Islamic higher education institutions, particularly Sharia and the law faculties. This conversation is not limited to the state law. We also examine the relationship between the state law, Sharia, and the socio-cultural realities in society. Indonesia and other Muslim countries live within a plural legal space. State, religious, customary, social, and modern needs continue to evolve. The question is how these elements can complement one another to protect human beings rather than cancel one another out. In this context, Maqasid al-Syariah make a significant contribution. Classical scholars such as Al-Ghazali and Ash-Shatibi did not understand Sharia merely as a set of the formal rules. They underlined that Sharia has higher objectives: the protection of religion, life, intellect, lineage, and property. The concept of maqasid can be reviewed as an ethical framework that closely associated with safeguarding human dignity. To protect life means that the law must safeguard human beings from violence, hunger, disaster, and arbitrariness. Protecting the intellect means paying attention to education, freedom of thought, and manipulation of information. Protecting lineage means not sacrificing families, children, women, and future generations for the sake of short-term policies. To protect property, economic justice, protection from exploitation, and access to livelihood resources must become central concerns. To protect a region, the state must provide space for faith and morality by ensuring that the region is not used as an instrument to oppress the weak. In Maqasid, it reads dynamically and contextually. It is not the antithesis of human rights. On the contrary, Maqasid can function as an ethical language that supports the human rights. Islamic values and universal human values need not be placed in opposition as if they must always stand against each other. Both point toward the same goal: preserving human dignity, limiting arbitrariness, and fulfilling social responsibility toward the weak. John Rawls' theory of justice requires us to imagine the principles of justice from behind a veil of ignorance, where we are unaware of whether we will be born into life of wealth or poverty. belonging to the majority or minority, possessing good health or in a disability, or as a citizen or refugee. In my view, democracy has strong moral resonance. A just law must be crafted with the understanding that any of us could potentially be in the most vulnerable situations. When we formulate law from the standpoint of the powerful, the outcome often benefits only the strong. However, only then does the law have a real chance of being accepted as far when we imagine ourselves as the weak. In the Islamic tradition, the measure of nobility of power is not how magnificent its place is, but how safely the weak can live under that power. In the modern constitutional tradition, a state governed by law is not the state that produces the most regulations, but the state whose power is most effectively limited by the human right and the human dignity. Although these two languages might be different, there is no reason for the moral direction cannot converge. Today, we face a new terrain that classical framers of the legal theory could not have imagined: the digital world. Artificial intelligence, big data, electronic code, financial technology, digital public services, and algorithmic decision-making systems have transformed the interaction between citizens, the state, and the market. Technology offers extraordinary convenience. Individual can remotely access services. Process can be accelerated. Data can assist in developing more accurate policies. However, technology is never entirely neutral. It carries the values of those who design it, the data that transit, and the interests that fund it. If the data used are biased, the decision produced might also be biased. If access to digital services is unequal, those already left behind will be neglected even further. When algorithms are treated like unquestionable judge, human beings lose the opportunity to defend the right. I have often emphasized that natural human intelligence must remain the ultimate guide during AI advance. Natural intelligence encompasses more than just the capacity to calculate or retain information. I mean wisdom, integrity, empathy, a sense of responsibility, and the moral capacity to ask the following question: is this decision just? Will it harm ordinary people? AI might help judge identify patterns in decisions, but it must never replace the judge's consent. AI may help the government read risks, but it must not use as an excuse for ignoring citizens' rights. AI might accelerate legal processes, but we must never allow those without devices, internet access, or digital literacy to be treated as a second-class citizen. In the past, inequality within the legal systems often arose from the person's inability to pay for the legal services. Today, inequality might arise from a lack of digital access, low data literacy, inability to challenge automated decisions, or lack of understanding of how data are used. Forms of inequality have changed, but the underlying ethical question remains the same. Can everyone access the law? Therefore, AI governance should never left a purely technical discussion among engineers. It must become a dialogue involving many fields, legal scholars, Sharia experts, philosophers, sociologists, policymakers, judges, and civil society. Transparency, accountability, data protection, objection mechanism, and human oversight must be ensured. Technology must be subject to the principles of human ethics. Distinguished guests, ladies and gentlemen, justice for vulnerable groups is not merely a national agenda, it is a global agenda. Refugees, migrants, cross-border workers, human trafficking victims, cybercrime victims, and communities affected by the conflict often live in contexts that exceed national boundaries. Throughout my experience in various international forums, including the ASEAN African Legal Consultative Organization in New Delhi, India, ASEAN, or Organization of Islamic Cooperation, APEC, and the Human Rights Forum in Geneva, I have observed one reality. Despite states having different legal systems, histories, and interests, human suffering communities communicate a single universal language. During my involvement in negotiation and the signing of international instruments such as the United Nations Convention Against Transnational Organized Crime in Palermo, I learned that today's crime moves across borders far from more quickly than government bureaucracy. Human trafficking, smuggling, money laundering, cybercrime, and migrant workers' exploitation do not stop at immigration checkpoints. National law must be strengthened, but international collaboration must also grow. On June 29, 2026, I had a meeting with Dato Sri Anwar Ibrahim, Prime Minister of Malaysia, to discuss the legal cooperation between Indonesia and Malaysia. The relationship between Indonesia and Malaysia is far from ordinary. We are two countries which share roots and deep closeness in the terms of history, language, culture, and of course, extensive human ties. I have a paternal lineage from Johor. Therefore, when I speak about Malaysia, I should not only as a government official, but also with a sense of kinship. Perhaps that is why I never feel too far from home in Malaysia. Yet, behind the closeness lies a set of serious responsibilities. Many Indonesian citizens work in Malaysia. Many families live through cross-border bond. Many legal issues require coordination, protection from migrant workers, law enforcement, immigration administration, legal assistance, and cooperation in correctional affairs. Countries sharing a border must show that cultural affinity can be converted into legal safeguards. Here, the role of academics becomes very, very essential. The government needs deep research, not merely general recommendations. Judges need studies that understand social realities and not only abstract theories. Civil society needs strong legal arguments, not merely expression of moral anger. Postgraduate students must have the courage to investigate complex problems and choose safe topic for publication. I would like to convey a message to the present scholars of law and Sharia. We do not allow our research to become a written legal record isolated from reality. The gap between written law and existing social condition has often been noted. While that is crucial, it is insufficient. The next responsibility is to explain why the gap persists, who benefits from it, who suffers from it, and what institutional design can help reduce it. Social legal research is crucial because it compels the law to engage with the human life as it actually lives. This demonstrates that the legal certainty and substantive justice are not opposites. They must interact with correct one to another. Certainly, without justice can harden into rigidity. Justice without certainty can turn into arbitrariness. Judges, policymakers, and academics must maintain this balance with sharp and clear thinking. The conference is situated in a strategically important location. UN Syarif Hidayatullah, Jakarta, has a rich tradition of studying Islam, law, and society. UN Maulana Malik Ibrahim, Malang, draws intellectual strength from the Islamic scholarly tradition in diverse social contexts of East Java. The University of Malaya brings an important perspective from Malaysia in international academic networks. If these three institutions collaborate consistently, it is entirely possible for a center of thought on law and justice to emerge with a significant regional impact. However, academic collaboration requires more sustained effort. It requires quality publications, joint research, faculty and student exchange, policy brief that policymakers can access, and the intellectual courage to address uncomfortable issues. The extent to which the family law protects women and children without sacrificing family values. We need to study how zakat and wakaf can function as instrument of social justice in more productive and measurable ways. We must consider how digital codes can expand access rather than widen inequality. We must also study how environmental law can protect indigenous communities and future generations, examining how Sharia, human rights, and state law can enter into dialogue without beginning from mutual suspicion is equality important. Above all, we must ensure that the law remains the site of humanity. If the law prioritizes order without question, it becomes rigid. Therefore, our shared responsibility is to integrate reasons, norm, consent, and concern of vulnerable individuals. Reflecting again on law and justice doesn't mean that every inheritance from the past must be rejected. As though the old was always wrong and the new was automatically better. The law does not function like a fashion trend that must be periodically changed to remain relevant. Our legal tradition must preserve key values such as certainty, responsibility, deliberation, protection of the vulnerable, and respect for the human dignity. We must objectively evaluate the aspect of our legal systems that no longer meet the present demands. The reimagining of law is not destruction without direction. The courage of prepare, reorder, and revive the fundamental purpose of law is needed. which is safeguard human life, restrain power, and guarantee that justice not only lies the creation of the legal regulations, but also permitted society's everyday reality. For me, the answer begins with the one principle. The weak must not be treated as peripheral to the legal system. They must be positioned as it is center. Children who encounter the law, women subjected to violence, individuals with disabilities seeking justice, migrant workers separated from their families, indigenous communities facing loss of their homes, low-income individuals intimidated by the legal system, and refugees uncertain about their futures. All of them are not objects of pity. They are legal subjects. These people possess dignity. An advanced rule of law state is not the most harshly punished. An advanced rule of law state is characterized by its ability to limit its own authority, its effectiveness in safeguarding vulnerable individuals, and its transparency in acknowledging when the system has failed to function as intended. Distinguished guests, ladies and gentlemen, it is very hope that the 10 ICLJ will become a forum where intellectual restlessness and moral commitment converge not only collected papers, but also fostering lively debate with the plenary session speakers and parallel sessions participating, engaging the sharp discussion with maintaining academic integrity. Criticisms toward argument should be sharp but respectful toward human beings. This is one of the finest traditions of scholarships. I hope that progressive ideas will emerge from Malang, ideas that flow into journals, fill classrooms, enter courtrooms, offices, government, rich communities, and find the way onto the tables where policy is made. Good scholarship doesn't always change the world immediately, but it changes the way we see the world. From a changed viewpoint, policy may change. From a changed policy, human life may also change. Finally, I want to congratulate UIN Syarif Hidayatullah Jakarta, UIN Maulana Malik Ibrahim Malang, and the University of Malaya for convening this conference. 10 years of ICLJ is achievement for which we should be grateful. However, as with all academic achievement, an anniversary is not the end of a journey. It is a reminder that intellectual works must be constantly renewed. May Allah subhanahu wa ta'ala grant us the strength to make law an instrument of protection and not a tool of oppression. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.